In the court's protective capacity, honorable members, courts serve to defend fundamental elements of the constitutional order from being altered or destroyed. In such contexts, such as ours, with a history of authoritarian rule, which is also characteristic of many fragile African democracies, judicial review reinforces democratic governance by safeguarding core structures of democracy from being eroded. Courts, therefore, are the foremost to defend the devolution. In every instance where devolution has been threatened, the courts have listened to the calling, and specifically the Supreme Court has stepped in to defend the spirit of the devolution. On the 15th May 2020, the Supreme Court rendered an advisory opinion on how the recurrent failure between the Senate and the National Assembly to agree on the Division of Revenue Bill would be resolved. The court directed that funds equivalent to 50% of the previous year's allocation should be disbursed to the counties whenever the legislative chambers have not agreed on division of revenue between the two levels of government, despite the commencement of a new financial year. In the CDF case 2022, the Supreme Court held that it is unconstitutional to allocate funds to the CDF before the division of revenue between the national and county governments. In addition, it was the position of the Supreme Court that the CDF offends the division of functions between the national and county governments to allow a CDF an instrumentality of the national government to undertake functions devolved to the counties. This clearly underscored the separation of power and that delivery of service is devolved to the county and the constituency is subsumed within the county, just the same way as the ward is. In the context of the devolution of governance, the Supreme Court of Kenya has similarly played a constructive role by developing jurisprudence that enables the institutions established under the devolved system of governance to operate effectively.
While both houses of parliament have legislative powers, all bills concerning counties must be considered by the Senate. On the other hand, all bills not concerning county governments are considered and passed only by the National Assembly. In terms of Article 109(5) of the Constitution, money bills may also only be introduced in the National Assembly. This functional distinction is a relevant consideration for various reasons. The first obvious reason is that it ensures that there is no conflict and/or overlaps in the discharge of the functions of either House of Parliament. The second, if this functional distinction between the Senate and the National Assembly does not operate as required by the Constitution, there is the risk of the legislative process being delayed or the resulting laws being declared unconstitutional. In previous financial years, we also have witnessed stalemates between the Senate and the National Assembly regarding the passage of critical laws such as the Division of Revenue Act, which forms the basis of the division of revenue between the national government and the county governments, and therefore sets the stage for the enactment of other laws to enable the expenditure of public funds. Whenever such delays occur, the ability of the executive and the other arms of government, and indeed of the county governments, to discharge their respective duties and mandates is seriously undermined.
The Chief Justice has actually thrown a challenge to us as legislators to to come up with legislative proposal to make it clear to all honorable members who are here that the difference between the other courts and the Supreme Court is that
because functions are supposed to be followed by resources, we need to stand firm and push what we have to do. At times, going by the example that the Speaker
for the last 10 years, I don't think we will have made it this far. And that's why it is very critical for us as a Senate
and get a holding back in this country. Thank you, Mr. Speaker.
Honorable Senator, let us be precise in our contributions so that we are. We'll start with Senator Olekina. Then we
actually now comes in and say the Senate was not consulted in this matter. And there are so many, even as early as yesterday. There are a lot of pieces of legislation which will...
for the Senate. Secondly, the issue of the conflicts between the Senate and the National Assembly. The Office of the Attorney
is a question directed to the judiciary and to the Senate. We spend a lot of money coming up with legislation.
somebody talked about it for the governors as well. We have to create a forum where this Montesquieu philosophy doesn't separate us, and we only... Actually, the Honorable, the Attorney General, and the Honorable, the former Speaker, in a way, revert to. Mr. Speaker said something about...
Go to the Dr. Sarunei, representing the Attorney General. Now, I happen to have served on the Commission for the Implementation of the Constitution. What you consider as being laws that are on devolved functions and laws that are not. The reason I say this, when you look at the fourth schedule of the Constitution...
The General in all our committees, is there a way JLAC can then try to consult with the judiciary so that we don't continue wasting public funds? Thank you so much, Mr. Speaker. The judiciary finds the legislation to be unconstitutional. Is there a way, and I know there's this thin line between the
service delivery on various functions to county governments, but on those very functions, policy making and setting standards is a function